term Hindi is any good. अभी तक बेसिकली इन जो मेन पॉइंट हैं वो एक तो 3% रिजर्वेशन जो लॉ में है, उन्होंने कहा है कि वो एक अफर्मेटिव मतलब एक कानून की तरफ से पॉजिटिव एक्शन है, और हमारे पास हिंदुस्तान का संविधान है और सब मेंटल हेल्थ एक्ट है, नेशनल ट्रस्ट एक्ट है और डिसेबिलिटी वाला लॉ है, और इन सब के और उसके साथ साथ वो यूएन का कन्वेंशन है, और इन सब के साथ कुछ अच्छे जजेस भी हैं, जैसे फिलहाल वक्त जस्टिस सीकरी जो हैं, जो दिल्ली हाई कोर्ट के चीफ जस्टिस हैं, जो इन कॉजेस पे, ह्यूमन राइट्स के कॉजेस पे बहुत अच्छे जजमेंट्स देते हैं। और एक रेलवे का केस ने साइड किया जिसमें जस्टिस सीकरी ने कहा कि जगमोहन जी देख नहीं सकते, मगर हमारी जो इंडियन रेलवे है उसको दृष्टि का प्रॉब्लम है, उसका दृष्टिकोण खराब है। तो जजेस का व्यू पॉइंट बहुत अच्छा है, जो हमारे लिए एक बहुत अच्छी बात है।
Look to the US, America is the country which we all look towards in terms of our social and economic path going forward. I thought I'd just compare briefly the disability law in India versus the US. One is that in India we provide reservation and quotas, 3% in education, 3% in employment, although that does not apply to the private sector. In the US, there are no quotas. I think that for disability, whether it is a developed country or a developing country, quotas are very important. There is a lot of debate about quotas amongst other disadvantaged groups, saying they've already reaped the benefits and it's time to stop reservation. But I certainly think not so for persons with disabilities, because without the benefit of education, the prospects of employment, whether in the private or public sector, are very, very limited. And even when it comes to employment, public sector employment is important, and not only that, it can also enable private sector employment. When some years back, the telecommunications industry started in India and was able to leap forward so fast because most of the employees that joined the private sector companies came from the public sector with expertise in telecommunications. And so I was talking to Mr. Reddy at the tea break, and he was talking about his son who has a cleft palate problem, and the son would like to join the private sector, but Mr. Reddy would like him to join the public sector civil services. Well, I feel there's a connection there, because if you have reservation in the civil services, after some 10 years of service and experience, you could very well qualify for the private sector with your experience and understanding of how the government works. So public sector quotas can also help in private sector employment down the road. But when it comes to the anti-discrimination provisions, the US American with Disabilities Act is very strong. There are blanket provisions in the American with Disabilities Act for non-discrimination against persons with disabilities, both in the public and private sector. And these are very broad definitions, where it may cover employment, it may cover access to public facilities, it may cover education. But either in the public or private sector, discrimination in the US is prohibited. And in practice, the courts in the US link the concept of reasonable accommodation to the idea of non-discrimination. So for example, if an employee acquires a disability in service and is terminated without the employer, be it a private employer, considering reasonable accommodation and considering alternative jobs, etc., that can allow the person to be functional, then the courts have said that no, you must consider reasonable accommodation first. And unless you prove to us that there is no reasonable accommodation possible, you must keep the person, even though he has become disabled during employment. That applies to the private sector as well. One of the other differences in the legal systems as it pertains to disability legal advocacy is that in the US, all action is initiated by lawsuits, filing a lawsuit in the civil court. Whereas in India, we have maybe a more effective mechanism, because we go directly with petitions to the higher courts, the High Court, Supreme Court, and the tribunals.
यहाँ इस स्लाइड में सर ने यूएस और हिंदुस्तान के कानून को कंपेयर किया है दोनों को, और बेसिकली उनका एक जो इम्पोर्टेंट पॉइंट है वो ये है कि जो हमारे पास 3% रिजर्वेशन है अभी तो वो गवर्नमेंट के लिए ही है, गवर्नमेंट के जो ऑफिसेज हैं उसके लिए। मगर अगर आप गवर्नमेंट में काम कर चुके हैं तो गवर्नमेंट में काम करने के बाद 5-10 साल काम करने के बाद आपको बड़े आराम से उस काम के एक्सपीरियंस के बेसिस पे प्राइवेट सेक्टर में जॉब मिल सकता है, प्राइवेट सेक्टर में काम मिल सकता है। तो ये लंबे स्तर पर एक अच्छी बात है। बट यूएस के कानून में कोई रिजर्वेशन नहीं है, वहाँ सबके लिए ओपन है और दोनों सेक्टर में ओपन है, चाहे वो गवर्नमेंट का हो चाहे वो प्राइवेट का हो। दूसरा, भेदभाव का वहाँ पे जो प्रोविजन है वो हमारे यहाँ से बहुत ज्यादा बेहतर है और वहाँ पे रीजनेबल अकोमोडेशन को भेदभाव का जो कानून है उसका एक बहुत स्ट्रॉन्ग हिस्सा माना गया है। पर हमारे यहाँ कानून में जब आप लिटिगेशन या केस फाइल करने जाते हैं तो हमारी पोजीशन ज्यादा बेहतर है, क्योंकि हम प्राइवेट केस भी ला जा सकते हैं और पब्लिक इंटरेस्ट लिटिगेशन भी ले जा सकते हैं।
Have powerful legal provisions. Then ultimately, how do we seek remedies? There is a well-known principle in law that there is no right without a remedy. If there is no remedy, then there is effectively no right. So ultimately, the point is to seek remedies, and how do we do that? Idea is not just to identify issues and feel injured and clamor about them. The idea is to go for actual action, whether it is out of court or in court, that results in certain benefits. And the first step for that is self-awareness and self-education. I think on every person with disability and every disabled person's organization must understand the issues well, must decide where is the deprivation, where is the unfairness, where is the inequity or lack of reasonable accommodation, and what is the appropriate remedy. This brings me again to a memory of a case I was before Justice Rajiv Gandhi in the Supreme Court, and again the issue was accessibility. And there I just wanted to give an example to Justice to the bench that look, for example, if there was a hearing impaired or deaf lawyer, he would not be able to argue before the court because he could not communicate, and it would be reasonable to have a sign language interpreter available, a sign language translator available, so that he could translate the arguments into what the court could understand. And the court right away said to me, well, do you mean that we should have a sign language interpreter available all the time in our courts for every single day in every single courtroom? And I said, no, that's not reasonable. But what is reasonable is just making arrangements, or at least allowing for a hearing impaired lawyer to come with his sign language translator to argue in court. That was the meaning of it. So the remedy has to be appropriate and reasonable. And most importantly, what is the law in support of the case? So one cannot be emotional about one's grievance. One cannot go thinking that there is a right without some basis in law, which is why to understand what legal provisions are is so important. And certainly the UNCRPD has really helped because it brings to bear a number of additional legal grounds, such as reasonable accommodation, that one can take recourse to. It's most important to communicate our case well to begin with, not just to the court, but even to the competent party, whether it is a public authority, whether it is an education institution, or whether it is an employer. It is important to communicate because of the lack of awareness on the part of most entities, public or private. Communication is important, and written communication is especially important. And also to the third party offices like the Chief Commissioner for Persons with Disabilities or like to disabled persons organizations. I recall the case of a gentleman in Dehradun who was orthopedically disabled, is orthopedically disabled, and after having spent many long years in Dehradun working at the ONGC, was going to be transferred to a different location altogether where he would not have the family support structure to help him with his disability and mobility, etc. Now there is a government circular that goes back to I think 1990 that in fact requires that public sector employers desist from transferring persons with disabilities to locations far away from their native place because of issues of mobility and other kinds of issues. Now Mr. Pandey was well aware of this particular circular, but when he communicated to his employer ONGC, he focused more on the fact that his mother was aged and ailing, rather than focus on what the law says. Now, a person's mother being aged and ailing is not a ground to not be transferred to a faraway location, but the law says otherwise. So I think it's important to communicate exactly what the law says and what an appropriate remedy is. And finally, if communication and attempts to work through third-party offices like the Chief Commissioner and the disabled persons organizations do not work, then the final path is to go to the court. And I think the most significant and the most effective cases are impact petitions, where there might be a person with disability who has an individual interest in the case and who is impacted by the case, but ultimately the outcome would impact the larger community of persons with disabilities. And also public interest petitions, where anybody, a disabled person's organization or anybody else, can file a petition in the High Court. They need not be themselves affected, but are filing for some relief that involves the public interest of persons with disabilities.
ये कहा गया है कि अगर आपको विधि के हिसाब से, कानून के हिसाब से आपके साथ अगर कुछ गलत हुआ है तो कोर्ट को या जो भी ऑफिशियल है उसको उसके पास जाना है, उसको समझाना है, तो सबसे पहले आपको खुद क्या गलत हुआ है ये समझने की आप में क्षमता होनी चाहिए, जिसके लिए कानून के बारे में और आपके क्या अधिकार हैं और गवर्नमेंट की क्या ड्यूटीज हैं या दूसरे लोगों की क्या ड्यूटीज हैं आपके प्रति, इसके बारे में आपको जानकारी होनी चाहिए। तो ये सबसे ज्यादा जरूरी है। उसके बाद फिर ये समझना कि आपके साथ जो गलत हुआ है उसके लिए क्या रेमेडी आप चाहते हैं, उसको मतलब उसको आप सही कैसे करना चाहते हैं, उसको सही कैसे किया जा सकता है, इसकी जानकारी होना जरूरी है। और आप जिसके पास भी जाएं, चाहे आप कोर्ट जाएं, चाहे आप वकील के पास जाएं अपना केस समझाने, या चाहे आप किसी ऑफिशियल के पास जाएं, आपको आप में इतनी क्षमता होनी चाहिए कि आप अपना प्रॉब्लम, आपके साथ जो गलत हुआ वो आप सही से उन्हें समझा सकें, उन्हें बता सकें, तभी आपको सही उसको सही करने का उपाय मिलेगा या आप उसको रेमेडी करा सकेंगे, आपके साथ जो गलत हुआ आप उसे ठीक करा सकेंगे।
But for the benefit of those persons from disabled persons organizations or other persons with disabilities, one of the unique things about Indian law, which follows British law, is the mechanism of writ petition. Again, when I compare it to the US, in the US, if you have any problem with either the public sector parties or private sector entities, you have to file a suit in the civil court, which amounts to the district courts in India. And that, as you know, in India is a very long, cumbersome process that requires evidence, it requires witnesses, cross-examination, etc. And that is a long process, and this is why cases in India are known to take so long. But we have in India the mechanism of the writ petition. It has its origins in the British monarchy at the time of the kings. So I guess we owe something to the kings of Britain. Basically, what happened there was that for small disputes,